Former Justice Department Special Counsel Jack Smith is sitting for a closed-door deposition with House Republicans this hour. House Judiciary Committee members digging into his investigations into President Trump. Smith arrived on Capitol Hill moments ago, as you see here, and this deposition is part of an ongoing investigation into criminal inquiries of President Trump during the Biden administration. Smith, as you'll remember, led the investigations into Mr. Trump's efforts to overturn his 2020 presidential election and the classified documents at his Mar-a-Lago estate in Palm Beach, Florida. CBS News Department of Justice reporter Jake Rosen joins us now from our D.C. bureau with more on this. Really fascinating, Jake, to know this is happening behind closed doors with lawmakers right now. What questions do we expect Jack Smith to answer, considering all of his cases were moot since Mr. Trump became president once again?
Well, Smith's representatives and legal team have said that he's open to answering any.
The silence after January 6th was never justice. It was a pause, a holding pattern, a legal coma induced by power. Picture this without sentimentality. The same Capitol hallways where glass shattered, where officers bled, where lawmakers barricaded doors with furniture. Now imagine members of Congress sitting quietly, reading sworn testimony that states, without hesitation, that the attack on their workplace does not happen without one man. Not metaphorically, not politically, causally, Donald Trump. The most culpable, the most responsible. That is not commentary. That is a prosecutorial conclusion delivered under oath by a man whose professional life has been built on restraint. And then comes the realization that detonates the room. None of it will be tested in a courtroom. None of it will be weighed by a jury. Not because the evidence collapsed, not because witnesses disappeared, but because the defendant won an election. This is the moment where the American legal system stops pretending it treats power neutrally. Jack Smith did not speculate. He did not hedge. He told Congress that his team possessed admissible, trial-ready evidence sufficient to convict Donald Trump on multiple felony counts related to the effort to overturn the 2020 election. He said the attack on January 6th does not occur absent Trump's conduct. He said Trump was not one actor among many, but the central driver of the scheme. And he said it knowing that, by the time those words became public, they would function less like an indictment and more like an epitaph for accountability. Because the law never reached the merits. It never reached guilt or innocence. It froze at the threshold of power. Strip away the noise and the partisan screaming, and what you are left with is something far more dangerous than corruption. You are left with a system that documents criminal conduct in exquisite detail and then declares itself powerless to respond once the accused occupies the highest office in the land. That is not a loophole. That is a design failure. The facts are not mysterious. Trump lost the 2020 election. He was told he lost, repeatedly, by state officials, by his own Justice Department, by his campaign lawyers, by courts across the country. And instead of conceding, he initiated a pressure campaign that touched every lever of government available to him. He leaned on state officials to alter vote totals. He endorsed the creation of fake elector slates designed to substitute fraudulent outcomes for legitimate ones. He attempted to conscript the Justice Department into declaring the election corrupt, despite the absence of evidence. He targeted his own vice president, demanding that constitutional procedures be violated to keep him in power. This was not chaos. It was structure. This was not emotion. It was planning. By January 6th, the objective was clear. Stop the certification. Delay it, disrupt it, or invalidate it. And when a mob marched on the Capitol, inflamed by lies and directed toward a single choke point in the constitutional process, the President of the United States watched. He watched as officers were overwhelmed. He watched as lawmakers fled. He watched as chants escalated from grievance to execution fantasies. And for hours, he did nothing to stop it. That inaction was not negligence. It was leverage. Smith's investigation mapped this sequence meticulously. Hundreds of witnesses, voluminous documents, internal communications, first-hand testimony from people inside Trump's orbit who admitted, plainly, that they knew the effort was illegal. One elector conceded they were attempting to overthrow the government and understood that fact at the time. That is not inference. That is confession. From a legal standpoint, the charges were neither exotic nor novel. Conspiracy to defraud the United States. obstruction of an official proceeding, conspiracy against rights. These are workhorse statutes used to prosecute organized criminal conduct that interferes with democratic processes. They carry real prison time. They require proof of intent, coordination, and action. And according to the prosecutor who assembled the case, those elements were satisfied. The point of a trial would have been to test that claim, to allow defense counsel to challenge witnesses, to allow a jury to weigh credibility, to allow a judge to rule on admissibility. That is how a system governed by law resolves disputes of this magnitude. That process never occurred. Instead, Trump executed a strategy that is now impossible to ignore. Delay relentlessly, appeal everything, exhaust the clock, and then reclaim power. Once back in office, the Justice Department's internal policy barring prosecution of a sitting president snaps into place like a shield. Not because Congress demanded it, not because the Constitution requires it, but because of a memo, an internal rule treated as immutable law, and layered on top of that is the Supreme Court's expansion of presidential immunity. Under this doctrine, actions taken as part of official duties are insulated from criminal prosecution. That phrase, official duties, is elastic enough to swallow almost anything when wielded by a determined defense team. Pressure on state officials becomes election oversight. Attempts to manipulate DOJ become executive supervision. Incitement becomes speech. Inaction becomes discretion. The result is not ambiguity. It is paralysis. Congress now sits with a record that says the president caused an attack on their institution and should have been convicted, alongside a legal reality that says nothing can be done about it. That is not accountability deferred. That is accountability denied. And here is where the pattern matters. Authoritarian systems do not begin by abolishing courts or canceling elections. They begin by rendering consequences optional for those at the top. They preserve the appearance of law while hollowing out its force. The rules remain in place for everyone else. The paperwork is meticulous. The reports are thorough. The conclusions are damning. But the endpoint is predetermined. Power absorbs the shock. Trump did not invent this playbook, but he perfected it for the American context. Commit acts that push the boundary of legality. Litigate endlessly. Frame every investigation as persecution. Mobilize supporters to delegitimize institutions. And if you can reclaim office before the process concludes, the process collapses under its own weight. That is not clever lawyering. That is systemic exploitation. What makes this moment uniquely corrosive is not just that Trump avoided a jury. It is that the avoidance itself is now precedent. Future presidents are watching. They are learning that if they can survive the immediate fallout, the long-term consequences can be neutralized. Delay becomes a weapon. Immunity becomes a refuge. Elections become a reset button. This is how democratic erosion actually happens. Not with tanks, but with memos. The reaction in Congress reflects this reality. Those who experienced January 6th firsthand understand the dissonance viscerally. They were hunted in those halls. They were evacuated under guard. And now they are told that the architect of that day walks free not because he was exonerated, but because he is untouchable. That distinction matters. Innocence implies vindication. Untouchability implies hierarchy. Republicans dismiss Smith's findings as political because acknowledging them would require confronting the implications. Democrats cite them as proof of guilt, but lack the leverage to translate evidence into consequence. The divide is not just partisan, it is epistemic. One side believes law constrains power. The other believes power defines law. And because there will be no trial, there will be no authoritative resolution, no verdict, no sentence, just parallel realities that never intersect. Trump's supporters will say the absence of conviction proves a witch hunt. Trump's critics will say the absence of conviction proves a rigged system, and both will cite the same fact: nothing happened. Meanwhile, Trump is not retreating. He is advancing. He is leveraging the Justice Department to pursue perceived enemies. He is threatening judges. He is probing independent institutions. The system that failed to constrain him is now being actively weaponized by him. That is not irony. That is outcome. This is why the focus on whether Trump should be in prison, while emotionally satisfying, is incomplete. The deeper question is what it means for a republic when evidence of criminal conduct at the highest level can be formally acknowledged and then functionally ignored. What message does that send to future office holders? What incentive structure does it create? The answer is bleak. It teaches that the only unforgivable sin is losing. Jack Smith's work will live on as part of the historical record. Scholars will parse it. Future generations will read it. They will understand that the attack on January 6th was not spontaneous and that responsibility was traceable. But history is not enforcement. Memory is not deterrence. The Constitution does not enforce itself. It relies on institutions willing to act even when doing so is politically dangerous. In this case, those institutions blinked. Some because of fear, some because of doctrine, some because of inertia. The reason matters less than the result. The result is a system where a president can attempt to overturn an election, face overwhelming evidence, and emerge more powerful than before. That is not a glitch. That is a warning. If accountability depends on timing rather than conduct, then law becomes theater. If immunity expands to cover abuses of power, then office becomes armor. And if elections can be used not just to choose leaders, but to erase liability, then democracy becomes transactional. This is the historical weight of the moment. Not that Trump escaped prison, but that the system proved incapable of compelling an answer to the most basic question. Can a president be held criminally responsible for attempting to subvert the constitutional order? Right now, the answer appears to be no. And that should unsettle anyone who believes that democracy is more than ritual. If you care about where this leads, if you want to track how power continues to test the boundaries of law in real time, stay alert. Because the most dangerous developments rarely announce themselves. They accumulate quietly until the silence becomes permanent.